Welcome to Chapter 13 video presentation devoted to closing procurements. This video presentation, just like all video presentations in this course, is based on the book titled Project Procurement Management, Contracting, Subcontracting, Teaming by Quinton Fleming. Below are the learning objectives for Chapter 13. After completing this chapter, you should be able to explain when a contract termination due to the default of a seller may occur. You should also be able to list and briefly discuss the two types of contract breaches. You should also be able to explain the conditions that a buyer must satisfy in order to terminate a contract for convenience causes. You should also be able to explain why most contracts do not provide for an absolute right to terminate a contract. You should also be able to explain why notice of contract termination is important, explain why it is often difficult for a company to have a person in charge of closing a particular project. You should be able to list and briefly discuss the 4 common ways of settling disputed seller claims. You should also be able to list the documents that need to be preserved and stored for each project, and also to explain the importance of the lessons learned report. So these are the learning objectives for Chapter 13. We will start with some preliminary thoughts. Procurement is not completed when the seller produces all the deliverables specified in a contract. Oftentimes, even after the delivery date, there are some residual issues remaining, and those issues include a formal closure of each procurement. So this is something that has to be done after the delivery of a product or service by the seller. Also, storage of all files associated with each procurement, and then settling of all outstanding changes and residual claims from the seller. As the time goes by, it is the seller who has an upper hand with all outstanding issues. So if buyer is delaying settling all outstanding issues, then the seller will either move on without providing proper documentation, let's say, or take the buyer to court in case there are some outstanding charges that the buyer owes to the seller due to, let's say, some changes to the procurement scope that were initiated by the buyer. So it is in the best interest of the buyer to settle all outstanding issues as soon as possible. Now, the best way to end a procurement relationship is to have the seller completely satisfy the statement of work by making all the deliverables and complying with all the provisions of the contract. So this is the best way to end a procurement relationship. But there are some situations when either the buyer or the seller may want to end the contract before the completion of the procurement. Now, before either the buyer or the seller decides to terminate a procurement relationship before the steps or the date specified in the contract, both should seek legal advice, because that may involve violation of some contractual terms unless such terminations are an explicit part of a contract. There are 3 common scenarios or situations for ending a procurement before the date or the conditions specified in a contract. And those scenarios include the following. I think the first one is the most common one: termination for cause of default. And this is something due to actions or lack of actions on the side of the seller. So to make it very simple, the seller does not deliver what was agreed upon in a contract, and for those reasons the buyer decides to terminate the contract. So that's the first category, and it's probably the most common one. The second category of scenarios is termination for convenience of the buyer, meaning the seller is doing the job, is delivering the scope that is specified in the contract, but for some rather legitimate reasons, the buyer will decide that it will be more convenient for the buyer not to continue the relationship, and that will cause the end of the procurement relationship between the buyer and the seller. And then the least common one is the absolute right to terminate the agreement by either the buyer or the seller. So in some rare circumstances and in some rare forms of contracting, either the buyer or the seller or both may have an absolute right to terminate the procurement relationship without explaining much. So that will be another mechanism or another scenario for terminating a relationship between a buyer and a seller. Now let's start with the first category: termination for cause of default. It usually happens when the seller does not fulfill the critical requirements of a contract. The legal term for this scenario is breach of contract, which means violation of contractual terms. Breach of contract is typically defined as failure without legal excuse to perform any promise which forms the whole or part of a contract. Now, oftentimes the important word material is added to the breach of contract. As they call it, material breach of contract, and then the definition becomes failure without legal excuse to perform any promise, any material promise which forms the whole or part of a contract. So what this word material means: the event must be significant and not just a minor annoyance, and central to the relationship in order for a contract to be breached. For example, if you're hiring somebody to clean your office, you're hiring a professional cleaning organization, and then the cleaning organization agrees to perform cleaning services every working day, which means usually 5 times per week. And then you're annoyed by the fact that they're using a cleaning chemical with a particular scent, and your employees are complaining about that scent. Let's say most people find the scent of citrus, let's say in your office, to be annoying. Then this is not a material breach of contract. I mean, this is something that is not central to the relationship between you and the professional cleaning company, right? The scent of the soap or of the chemicals being used. So for those reasons, you cannot accuse the vendor, the professional cleaning company, for breaching the contract. However, if they fail to perform cleaning services as promised, for example, they just they're absent for the whole month, there is nothing performed for the whole month, then this is a material breach of contract, meaning them failing to clean your office for several weeks is something that defeats the whole point of having a cleaning company working for you. So for those reasons, you can terminate the contract. Now, so those are like 2 extreme examples, right? Everything in between can be subject to negotiations and subject to debate. For example, what if during the month the cleaning services are performed 4 times per week and not 5 times per week, right? Is this a material breach of contract or not? So some people would say, yeah, it's material because one day, one day of the week involves an employee working in a environment that is not clean, so that's material, that's demonstratable, that's something that can be translated into monetary terms, therefore it should be material. While others may say, well, the fact that they fail to clean your office on one of the Fridays constituting the entire month is not a big deal, and it's not a material breach of contract. But nevertheless, the breach of contract means, the breach of contract situation means the seller fails to perform what was promised. Now, a breach does not have to be actual, something that is observed. There are 2 types of breaches of contract that can be used to claim a breach of contract before any kind of substantial action actually happens. So one of them is anticipatory. It occurs when promisor, without justification before he has committed a breach, makes a positive statement to promisee indicating he will not, or he or she will not or cannot perform his or her contractual duties. So it basically means something like that. The seller, the cleaning company, tells you that we won't be able to perform our services anymore. Let's say next month, right? So that means that they will breach the contract next month, and you don't have to wait until that event to actually occur to terminate the contract. Then you also have constructive. Takes place when a party bound to perform disables himself or herself from performance by some act or declares something indicating that the seller will not perform. An example of that would be something like your cleaning company has not declared that they will not be able to perform any cleaning services starting next month. However, you know that they gave layoff notices to all of their cleaning employees. In other words, they told them that they will be out of work starting next month. So the question becomes, if all of their employees will be laid off next month, then how will the company perform cleaning services for you? So this is like an action that tells you that the vendor, that the seller will not be able to perform the services. Now, Obviously, there may be some serious consequences for breaching a contract. I'm talking about consequences to the seller. So one such possible consequence is that the seller may not be entitled to any profits from the work performed. So you're not gonna pay zero to the seller if some portion of the promised work has not been performed. You will compensate them for the costs incurred for performing a portion, let's say for cleaning the office for, let's say, 3 weeks out of 4. However, because they breached the contract, they may not be entitled to any profits from those cleaning services. You will only compensate them for the cost, right? But you will not allow them to make any profit on this relationship. Also, sometimes sellers may not be eligible for fully recovering the cost incurred. So for example, you may say that one of the material damages cost is that now we need to spend time and money searching for another cleaning company. So we'll not compensate you for the cost fully because we will subtract the amount of money needed to find a new cleaning company from the amount that we would otherwise pay you to compensate you for the cost incurred for cleaning our office for 3 weeks out of 4. Sometimes the seller is liable for compensatory damages to the buyer for the cost necessary for taking the project to another seller. So yeah, I gave you an example of that. So in that case, the incurred cost will not be fully compensated for. Sometimes issues arise when it comes to compensating lower tier suppliers. Your vendor may be subcontracting several other companies to do the job. So typically the buyer will compensate the lower tier supplies for costs incurred and allow for some profits if the service performed are adequate. But this compensation may be charged to the seller at fault. So that could be subtracted from the partial compensation intended for the seller. Now, another scenario when a contract is terminated is termination for the convenience of the buyer typically. Under the federal acquisition regulations, the government reserves the right to terminate any contract for their own convenience. Private industry may also have such clauses in the contract, although they're not very common because in that case the contract becomes a bit one-sided where the buyer has this right while the seller does not. But it's not a simple thing to execute. The termination cannot be done on a whim. If the buyer decides to exercise such right to terminate a relationship, first of all, the seller must be formally notified. The buyer should help the seller minimize the additional costs incurred. Overall, the buyer is responsible for making the seller whole again, right? So it's not just, okay, I quit and you're not getting anything or you're not getting any further payments. There needs to be some kind of compensation mechanism to make the seller whole again. Or compensate them for any additional costs incurred in relation to retooling and abandoning this project. Also, the termination for convenience must be in good faith. There must be a legitimate basis for convenience. There needs to be some rationale. By the way, a lower price from another seller may not be legitimate reasons for convenience. But of course, courts often struggle with cases where a convenience case is actually masked as a default on the side of the seller. So a buyer gets or sees a better opportunity in terms of price or a better deal from another seller, and then they just mask this situation with the convenience clause to move on to another seller that seems to be offering a better deal. Now, also some contracts they contain a provision for absolute right to terminate the agreement. A clause can be inserted into a contract where the buyer or the seller or both may have the right to terminate the contract for any reasons by simply giving a notice to another party. Now, of course, this provision is not very common as it negates the whole purpose of having a contract. I mean, why would you agree to something where both parties have the right to exit that agreement without any explanations, right? However, this provision is common in some industries, in some types of relationships, for example, in employment contracts or contracts for provision of professional services. Both parties, meaning the buyer, the consultant, the buyer, the organization hiring somebody, and the employee, whether it's a full-time employee or contractor or consultant. So both parties typically have the right to eliminate, to end the relationship. Typically, the only requirement is to give some days of notice. Let's say you need to notify 2 weeks in advance that you're quitting or something like that. But that's about it. So So in those kind of employment relationships, the absolute right to terminate the agreement seems to be present, seems to be quite common. Now, regardless of under which scenario a contract is terminated, the notice of a contract termination is very important. It's very important to give a reasonable notice to the other party that the relationship will be terminated. By the way, silence is not enough. Simply by avoiding your partner and not communicating, you are not formally terminating the contract. A formal notice, either in written most of the time or verbal form, is required by a number of legal codes, including the Uniform Commercial Code, or UCC. Now, another issue with closing procurements is having somebody in charge of the project when the project needs to be formally closed. You see, projects often start or continue without a project manager, so the project is already ongoing and they're trying to hire somebody to run this project. Similarly, a project manager may be transferred to another project before completing the earlier project fully, okay? Because it costs money for somebody to have a project manager on payroll, so they want to use this resource, utilize this resource to close to 100% capacity without waiting for a project manager to formally close a particular project and transition to a new one. But if a project manager leaves, then a project deputy can be in charge or somebody who is the most senior technical person can still be left in charge of the project and in charge of formally closing the project. Things can become quite costly if unsettled claims from the seller are not addressed in a timely fashion. In that case, sellers will be eligible for additional compensation in the form of fines. So mature organizations, they usually try to prevent such nobody's in charge situation, as this can lead to serious financial issues later on. Now, it is important to settle all of the outstanding seller claims. Changes in procurement projects are expected, but they need to be properly managed. Ideally, a provision for changes should be made in the contract. In other words, if the buyer requests change or if the seller wants to propose a change to the contract, how they should go about it. A lot of times those requests for changes come from the seller, and if they come from a buyer, right? So sometimes it's the buyer. Oftentimes it's the buyer who asks the seller to make some sort of modification to the originally agreed upon scope, and that makes seller eligible for some sort of equitable adjustment to their contract price due to such changes. So they will say, well, okay, I will do that, I will comply with your request, but that will involve additional time or additional costs on my side, so we want to be compensated for that. If a buyer disagrees with those adjustments, with those requests from the seller, or overall there is a dispute between the buyer and the seller as to what needs to be done and who is responsible for those changes that are introduced later during the procurement relationship, then there is a dispute, right? If there is a disagreement whose fault it is and who owes money to who because of those changes, then there is a dispute. Now, when people think about disputes, I think the first thing that comes to their mind is taking things to court, but that's not the only way to resolve it, and it may not be even the most common one, the most common method of resolving such disputes. There are some other common methods. For example, probably the most common one is negotiation between parties. Before taking things to court and spending months or years and spending a lot of money on lawyers, the two parties may just get together and try to negotiate a deal that seems to be fair on both sides. Sometimes disputes are resolved through mediation or arbitration, and that can be even a formal part of a contract. A mediation means both parties agree to appoint a mediator. Usually it's another organization or a specific person, a top manager from another organization, and it will be the responsibility of the manager to bring the two parties together and try to facilitate a deal that is fair to both parties and push both parties towards cooperation. So that's mediation. And sometimes the mediator is a person who is respected by both parties, who is impartial, and the mediator may or may not get any kind of compensation for those services. Sometimes disputes are resolved through arbitration. So this is something that is it's a procedure that is between mediation and a court litigation. So usually what happens under this mechanism is that both parties agree to some sort of panel of experts or judges. Now they're not formal judges; they're just people that they think have the credibility and impartiality to make judgments in the case of disputes. So the arbitration panel will look at the dispute and they will issue a verdict on the dispute, and both parties will agree to comply with this verdict. But of course, if even then doesn't work, the right to take things to court still remains. But that is probably the last option that most companies are thinking about, unless it's a very big company with a lot of lawyers on their payroll, so they have plenty of such resource to use. But even those big companies, before they take somebody to court, they will typically issue some sort of warning, or overall try to resolve things without taking any legal action, because again it's costly, it's time consuming. Taking things to court leads to a situation where a lot of operational details have to be made public, and this is something that companies don't want. Finally, when it comes to formally closing a project, it is recommended that the following documents are preserved in the archives. And I'm not gonna go through all of those documents in the list. You can just pause this video for 1 minute and read this list. And also this list is continued here. Now, one of the most important documents that need to be submitted to project archives is the lessons learned report. There is a concept of a learning organization, an organization that learns from its past projects and past mistakes. If an organization doesn't learn anything from its past projects and past mistakes, then it will never improve. It will continue making the same mistakes and losing money, losing time, losing resources. Oftentimes, projects reinvent the wheel. Projects are initiated without the knowledge that a similar project was initiated in the past. So that's why lessons learned report is very important, to have a formal record of each project, and also the knowledge, the lessons that were gained from each of those projects. So this completes chapter 13 video presentation.